Well, when you read when you read the judgment, at the core of it seems to be a question around what is the discretion of a political party in respect of its election list. And that's probably the kind of clarity that the court sought to provide. You would see that in the judgment they make the point that the political party decides who to field, which candidates to put on its list, out of its own process, and there's no process prescribed for that. However, it sets a timeline. It indicates that by the time or the date set by the ECN in terms of the Act, that when that list is to be submitted, then that's the list that will be taken, because it also then has to be gazetted. However, there's still room for any political party, should there be any change, to amend that list. But that opportunity must be exercised before polling day.
Okay.
When polling day arrives, then that list can no longer be amended. And that's the clarity I think it provides with regards to that. It also then, there was a question around Schedule 4 of the Constitution, paragraph 4 thereof, which gives the political party the discretion to put anybody that they want once they have secured seats for the National Assembly. The court also, the Supreme Court now, also indicates that the exercise of that discretion is also limited to the timeline that we have indicated. So that's the kind of clarity that it provides, and I think it's an issue that really, for which clarity needed to be provided, and I think it's good in that sense.
Having said that, now we know that the rightful MPs in this regard only have 2 years left. Did the court make any determination on how they are actually going to be compensated for the previous years? And if the court did not make a ruling to that effect, how will the issue of payback, if any, going to be dealt with?
Well, yes, you are right. You're asking a good question. The court did make a pronouncement on that. What it did, it amended the judgment or the order that was given by the Electoral Court, which order of the Electoral Court meant that them becoming members of Parliament would be effective from the 20th of March 2020. However, what the Supreme Court now did was to say that becomes effective immediately. So it has no regard to the period that has lapsed. So as far as they are concerned, there is no talk about the period that has lapsed. However, there is an issue with regards to those that has served up to this period as to how that is going to be treated. And there the court also pronounced itself, saying that it is between those members and the National Assembly to find ways as to how they would be able to navigate through that. But if there are instances in which their participation in the business of the National Assembly would lead to any instances of unconstitutionality or unlawfulness, then the courts will be drawn in and probably determine one way or the other. But otherwise, it's really left to the National Assembly through its own devices to find arrangement and solutions around that.
So what lessons can be learned from this judgment, especially considering that PDM has been found to have acted irrationally and ECN, of course, having exercised powers it does not have legally?
Well, I think at the heart of it is another question with regards to the qualification of members or candidates to be fielded on political parties list. And one would now have regard to Article 46 and 47 of the Constitution. See, what Article 47 does is it states qualification for members of the National Assembly. Now, Article 46 speaks to those that will be vying for election to the National Assembly. And it requires that whoever is vying for that should be treated as if they were about to assume that role, even though we know that it's an electoral process and not everybody who's in that contest is going to make it. And I think that's where the challenge is. And if you would recall, for instance, the facts with regard to this case, the PDM initially submitted a list, which the ECN then advised them that there were members who would not qualify, who would not meet the threshold that Article 47 sets, and therefore submitted a revised list. But on the announcement, post the announcement of the election, they then seemingly resubmitted the initial list so that those members would now qualify. And the court also observed that those members would have now resigned from those other assignments and responsibilities and jobs they would have had. I think this is where really the problem is. And in this instance, it has not been resolved. And I'm praying for a day when Article 46, in the way it's, a literal reading thereof is not complicated.
Okay.
But the practical implication thereof is something that is going to be with us for a very long time. And I'm hoping that there would be a pronouncement with regards to how do you apply Article 46, knowing that we're talking about a nomination process that happens months before the election, and then there is a swearing in of members of parliament, which also happens months after the election has taken place. Now, are you saying this person should have been ready as if he or she is now walking into the National Assembly today? Or would you have regard to the fact that post the election, and after now they have determined that they have been elected to assume this role, now you subject them to those requirements? And I think, I'm hoping there's going to be a day when that is to be determined. Another question also, another issue that I think has probably not been settled carefully. Remember, I spoke to you that the court has been able to place the meaning of Schedule 4, Paragraph 4 of that Schedule 4 of the Constitution, and they placed it before the polling date. But when you look at the entire Schedule 4, it actually talks about the process after the election. Now you ask yourself, but why would they take Paragraph 4 of that and put it before voting date? Because the other paragraphs talk about what the parties would then be entitled to, how is the formula worked out as to how proportional representation happens, and all of this. Now, and then it says the party has the discretion to choose those. Now, how do you put this before the polling process, while the provisions, the paragraphs before that, speaks to a process after that? I'm not sure whether that has fully been settled, but because we are in a constitutional state that we are, and we know that Supreme Court judgments are actually final unless the court itself, through its powers that is given to it by our constitution, relook at it and probably find otherwise. But for now, they have placed that before polling date.